I'm Peter Jamadar. I'm a judge at the Caribbean Court of Justice and also the chair of the Caribbean Association of Judicial Officers, referred to commonly as the CAJO. CAJO is a association of judicial officers across the region, and we have judicial officers from, of course, the Anglo-Caribbean jurisdictions, as well as from Suriname and from the Curacao, Saba, Bonaire, under the umbrella of what is called the Joint Court. Those are civil law jurisdictions, and Dutch is their native language, but they are embraced under CAJO. Haiti is actually also a member of CAJO, even though recently it has not been actively involved. What do? We bring together judicial officers and we offer training, continuing judicial education. We do research, publications. We've just completed, for example, with the Judiciary of the Bahamas. It's been launched in January of this year, a criminal bench book for the Judiciary of Bahamas. And so we also engage in research, in gender, in well-being, in the areas that impact not just the work of judicial officers, but also the work of those people who interact with judiciaries, which would include, obviously, citizens, court users, attorneys at law. That's just a little nutshell of who we are and what we do. Yes. Regrettably, the membership is limited. People who fall within the category of judicial officers, and of course, those who serve judiciaries in research capacities. Yes. Basically, that is our mandate and a summary of what we do. So thanks a lot.
Yes, thank you very much, Justice Jamadar. And I really do believe that the training of judicial officers is critical, and we truly appreciate this collaboration with you, because directors and senior officers from time to time find themselves before those judicial officers, and therefore it is important that we understand what the law expects of us. So thank you so much, and we look forward to continued collaboration. At this moment, I would like to introduce this very beautiful lady, CCGI director, someone who is very dear to me. Camille, I really tried to see how I can reduce your profile. And I also said to myself, now I know why you wouldn't accept to be chair, because you have so much going on, you know. But I am extremely, extremely honored to be able to introduce Camille Facey, CD, a distinguished attorney at law whose career spans more than 4 decades of service to Jamaica in the fields of law, corporate governance, public policy, and business leadership. Soon we'll be saying Jamaica and the Caribbean. Yes. Thank you very much, Camille. She is currently the managing partner at the law firm Facey Law, where her practice is focused on corporate law. And I must say it is a joint firm with her lovely husband, who I have met and know he has tremendous patience, which is needed, because Camille is so busy with the many things she does. I'll summarize very briefly. For over 25 years, she has held senior management positions at regional and senior vice president, general counsel and corporate secretary at Cable and Wireless and Sagicor. She currently serves as the chair of HEART NSTA Trust, which is one of the largest training organizations in Jamaica. Of course, she's a director here on the board of the Caribbean Corporate Governance Institute. She's also on the board of ICT Authority and Winton Energy Limited, where she chairs their corporate governance committee. She's the honorary secretary of the private sector organization of Jamaica and the chair of its corporate governance and listed companies committee. She's also an active member of the Jamaica Bar Association, serving on its commercial law and conveyancing committees. Camille, thank you very much for making the time for us today to serve as moderator for today's significant court judgment series. So I hand over now the panel discussions into your hands.
Thank you so much, Kamala. I am so delighted to be here and to introduce this distinguished regional panel. We are so honored to have these colleagues of ours come to speak with us today about this judgment. So I'm going to get straight into it. Our first speaker is going to be the legendary Honorable Mr. Justice Andrew Burgess. Justice Burgess, he's a former judge of the Caribbean Court of Justice, a justice of appeal in the Barbados Court of Appeal, a judge of the World Bank Administrative Tribunal, serving as both president and vice president, a judge on the Inter-American Development Bank's Administrative Tribunal, serving as president and vice president, and most importantly to many of us who studied at UWI, a professor of corporate and commercial law, holding the distinction of being the longest serving dean of the Faculty of Law. We thank you, Justice Burgess, for all that you have put into so many of our professionals across the Caribbean. He will speak for about 30 minutes, and thereafter, the Honorable Mr. Justice Peter Jamadar from Trinidad will speak. He will speak next, and he will speak for about 12 minutes. He was admitted to the Bar of Trinidad and Tobago in 1984 and was appointed a puisne judge of the High Court in 1997. In 2008, he was elevated to the Court of Appeal of Trinidad and Tobago, and in 2019, he was appointed a judge of the Caribbean Court of Justice. He is chairman of the Caribbean Association of Judicial Officers, as you would have heard when he just shared with us about that. And he is deeply involved in judicial education, training, both regionally and internationally. And we can't leave out the fact, because it's very important, that he is a paddy diver and a swim coach. The rounded man. After Justice Jamadar, we're going to be joined by Ramona Vansluytman from Guyana. Now, Ramona is an attorney at law and corporate legal consultant with more than 25 years of experience in corporate, commercial, and regulatory law. She has served as a business development director of the Guyana Logistics and Support Services, corporate secretary and legal advisor to the Demerara Distillers Group of Companies and Diamond Fire and General Insurance Company Limited. She has lectured corporate and business law for the Institute of Chartered Accountants of Guyana, and she has served as an IDB consultant on legislative reform initiatives aimed at improving Guyana's business environment and international competitiveness. Our last speaker will be from Jamaica, Ms. Yualande Christopher, who has over 20 years of experience as an attorney at law. She is the founder of Yualande Christopher and Associates, a law practice specializing in civil and commercial litigation. In addition, she is Chief Executive Officer of Keyman Financing Limited. She serves as corporate secretary to the Jamaican branches of several multinational corporations, including MasterCard. She's a tutor in civil practice and procedure at the Norman Manley Law School. She's a member of the Jamaica Bar Association Civil Practice and Procedure Subcommittee and a member of the PSOJ Corporate Governance Committee, for which I am grateful. Ladies and gentlemen, what a distinguished panel we have this afternoon. So I want you to pay close attention, because this is a unique learning opportunity. And with that, I want to thank our panelists for being with us and invite Justice Andrew Burgess to lead us off with his presentation.
Moderator Facey, thank you so very much. Ladies and gentlemen, this afternoon, I will be presenting on the very recent decision of the Caribbean Court of Justice in the case of Beth Clifford and Betway Investment Group and LCW Investments. This case is important because it provides some much needed clarity on the question of piercing the corporate veil. Now, I may use interchangeably piercing the corporate veil and lifting the corporate veil. I'm certain that you are all aware of the fact that Lord Sumption, in the leading English case of Press and Petrodel, sought to draw a distinction between piercing the veil and lifting the veil. In Beth Clifford, two of our judges, Judge Jamadar, Justice Jamadar, and Justice Anna Wu, both disagreed with Lord Sumption's categorization or to finding a distinction between lifting the veil and piercing the veil. They were of the view that it was an exercise in semantics. So I will be advised by my two colleagues, and I will not attempt to draw that distinction which doesn't disclose a distinction between piercing and lifting. When I use the expression piercing, I intend to cover both what it would be called piercing and what would be called lifting. Now, my presentation this afternoon explores the decision of Beth Clifford, and I will refer to it as Beth Clifford. I will explore the decision, the principles it establishes, and its practical implication for those of you who rely on the corporate structure in everyday business. Now, you'll see displayed an overview of my presentation. I'll start by looking at the corporate veil, the doctrine and rationale. I'll then move on to how the common law has treated with the corporate veil. The Caribbean, it's important that we see how the Caribbean has responded to this doctrine. And then I'll move to Beth Clifford. I think it's important that we set a backdrop, if you will call it a doctrinal backdrop, against which we can measure the decision in Beth Clifford as it establishes so much. So I look at Beth Clifford in the CCJ's reasoning. I first of all look at the facts and procedural history, the litigation history of Beth Clifford, what the CCJ reasoned in Beth Clifford. And I will attempt to find what are the implications of the CCJ's decision for creditors and directors and other corporate actors. I will attempt to find what takeaways we can share with these actors. And finally, I will close the presentation. Let's start first of all with the question of the corporate veil doctrine. I'm certain that all of us are aware that the corporate veil doctrine was developed by the United Kingdom House of Lords case of Salomon and Salomon. And basically, this doctrine declares that the company is separate from owners and shareholders. That is the legal consequence of the doctrine in Salomon and Salomon. But the practical significance of the Salomon's doctrine is that it protects personal assets, facilitates investments and innovation. And for those actors, directors, shareholders, and so on, this is important because what it does is it insulates the personal liability of investors from the ravages of, say, for instance, insolvency or bankruptcy, as the case may be. So that this doctrine, from a practical point of view, is crucial. But like all other doctrines, this one has exceptions. And this is what we are dealing with this evening. The veil may be pierced on some occasions, and the question which we are looking at is, what are the occasions on which the veil may be pierced? Traditionally, there are certain grounds, a number of grounds which have been cited at common law to support or justify the piercing of the corporate veil. Very early in the case law, you see reference to fraud or sham transactions resulting in the lifting of the corporate veil. The problem with that is that when you look at the cases, there are several cases where the veil was raised, but where there was no allegation of fraud or sham transaction. The same with agency. As a matter of fact, if you read the decision in Solomon, the High Court decision was that the Solomon didn't enjoy the protection of the corporate veil because the company, according to the High Court, was a mere agent of Solomon. And the Court of Appeal agreed. But this was, of course, rejected in the House of Lords. Another common law doctrine which is said to occasion or justify lifting the corporate veil is what they call the facade theory. That is that the company is nothing but a facade, which sounds very, very, very colorful. But I would suggest that if you attempt to import any meaning to that, it becomes almost impossible to know what or when there's a facade. This has led to a more recent explanation in the case which I mentioned earlier, Preston Petrodell, the evasion of legal obligations. Justice Lord Sumption was of the view that the only case of lifting of what he called piercing the veil is a case of when you use a company to evade legal obligations, existing legal obligations, not obligations which are accruing, but legal obligations. His view was in those circumstances, those very limited circumstances, the veil may be lifted. The final explanation which has been given for lifting the veil and which finds some expression in the case of Beth Clifford is abuse of incorporation. The view is that you were given the right to incorporate was given by Parliament, and to the extent that you are abusing that right, that it justifies a lifting of the corporate veil. These are the justifications which were given traditionally by the common law for lifting of the corporate veil. Yes. Sorry. So I would just like to say before we get to Beth Clifford that if you could go back one kind of step, that these explanations, no one of them was accepted by the courts. None of them had their genesis in the Companies Act. You have to remember that the Companies Act is what gave the right to incorporate to investors and other actors. But none of these grounds which were advanced for justifying lifting the corporate veil actually depended or based themselves on the Companies Act. Apart from the abuse of incorporation privilege, the others did not. So when the case Beth Clifford reached the CCJ, the law in the Commonwealth Caribbean was such that there was no significant appellate pronouncement in the region on what justified lifting the corporate veil. In one Jamaican case, Justice of Appeal, I don't think that he was president then, he was Justice of Appeal, Dennis Morrison, Justice of Appeal Dennis Morrison, did attempt to explore the question of lifting the corporate veil. But in the end, he based his decision almost exclusively on the Crescent Petrodel decision. So there was nothing in the Commonwealth Caribbean on which the CCG could bite. Yes. So this is the case of Beth Clifford. We can now look at the facts of this case. This is a case where LCW contracted with Green Development Partners for the purchase of land and the building of a house, the construction of a house on this land. Now, bear in mind that the contract was between LCW and GDP. We'll call them Green Development Partners, we'll call them GDP for convenience. Now, payments, according to the contract, were to be made not to GDP, but to Beltway Investment. So that's why I have a line going here, the payment as per the contract, which was not between LCW and Beltway. The payment was supposed to be made to Beltway. Now, what you need to notice is that both the companies, Beltway and GDP, were companies which were controlled by Beth Clifford. Now, there were delays in the obtaining of title and the construction of the house, and LCW eventually rescinded or repudiated the contract and sued for various things. Yes? He sued for breach of contract, and he also sued Beth Clifford as well as the company Beltway. So the breach of contract was against GDP, but he also had claims against Beth Clifford and Beltway. Now, the claim against GDP in the High Court was upheld, but the cases against Beth Clifford and Beltway were both dismissed. The reason given by Madam Justice Young was that there was no fraud, no misuse of the corporate structure, that Clifford had acted only as a director, shareholder, and that Beltway was nothing more than a party who was receiving something as per a contract between LCW and GDP. Yes. The Court of Appeal of Belize took a very different approach to the High Court. That court held that the corporate shield should be lifted. Of course, I should say that the court, first of all, held that GDP was correctly held liable for breach of contract. But it went on to hold that the corporate shield should be lifted. And it did that to impose personal liability on Beth Clifford and impose joint liability on Beltway. Now, the reasons which were given by the Court of Appeal are interesting. Yes? Yes. Why did the Court of Appeal think that the veil should be lifted? The Court of Appeal thought that Clifford controlled both companies, that is Beltway as well as GDP. And because the contract required payments to be routed through Beltway, this structure was treated as inherently suspicious. And it's interesting to read the judgment of Mr. Justice, the lead judge in the case. As a result, he expanded the lifting doctrine in Belize and held that the lifting doctrine would apply in these circumstances, in circumstances where the company is controlled by, where the companies, are controlled by a given shareholder or director, and where the structure, in his view, was inherently suspicious. So this is the case, this is the state of the law in Belize, which presented itself to the CCGI in the appeal by Beth Clifford and Beltway to the CCGI. Yes? When the case reached the CCGI, the judges focused on two key questions, correctly focused on two key questions, I would add. The questions were, was the Court of Appeal justified in piercing the corporate veil to make Clifford personally liable? And could Beltway be held jointly liable for GDP's breach simply because it received the payments? Yes? The CCGI held that the answer was clear. And I think, to the credit of the CCGI, the judgment was unanimous. Some judges didn't opine on the question of the lifting of the corporate veil, but there was a unanimous holding in the CCGI that the decision of the Court of Appeal had to be reversed. The appeal was allowed, and the Court of Appeal's decision was set aside. The High Court's ruling was restored. In short, the CCGI held that there was no legal or factual basis to lift the corporate veil. Yes? The CCGI took the opportunity to restate the law in firm terms. The corporate veil may only be lifted, according to the CCGI, if the corporate structure is being used for an unlawful purpose or in abuse of the privilege of incorporation. The judgments of Justice Anawu, who gave the judgment of the court, and Mr. Justice Jamadar, I think they repay very close reading. They're, in my view, examples of the best of Caribbean legal reasoning. The justices went back to first principles and found that the lifting of the veil doctrine was sort of implied in certain provisions of the Companies Acts. And as a result, the only thing in the Companies Acts which allowed for the disregard of the veil, which was allowed under the Companies Act, is one where the company was being used for an unlawful purpose or in abuse of the privilege or amounted to an abuse of the privilege of incorporation. The CCGI was emphatic on what did not amount to a lifting of the veil, or what would not allow for lifting of the veil. And I think it's important that we pay some attention to these. It said that common ownership was not indicative in itself of lifting the veil. Corporate control was not. Intercompany payments were not. Complex corporate structures, these were immaterial according to the judgments in the case, without wrongdoing. The veil could only be lifted if there was wrongdoing, and the veil remains intact if there is no wrongdoing. That is the major finding or ratio of the CCGI's decision in Beth Clifford. Yes. The CCGI then turned to Clifford's personal liability and found no evidence that Ms. Clifford acted improperly. The CCGI pointed out that she did what all business owners do every day. She operated multiple companies. She directed their affairs. She structured transactions in a way that made commercial sense. None of that amounts to abuse. There was no fraud, no deception, no misuse of corporate form. Therefore, the veil remained intact, and she was not subject to personal liability. Yes. Beltway's liability was also denied by the CCGI. The CCGI, as a result of investigating the facts of Beltway, they held that Beltway could not be held jointly liable. It was not a party to the contract. It simply received payments because the contract between LCW and GDP was to send them the payments under the contract. There was no evidence that Beltway acted improperly, and no evidence that Beltway engaged in an unlawful purpose. So that neither Beltway nor Clifford were held liable as a result of the lifting of the corporate veil. Yes. So what is the significance of the decision? First, it reins in an overly aggressive approach to veil lifting. And I think that this is to be welcomed. Second, it reaffirms the strictness of the doctrine of veil lifting. And it emphasized that veil lifting is a way of last resort. It protects the legitimate corporate structuring. And finally, it brings clarity and predictability to Caribbean company law. You have to bear in mind, if the decision of the Court of Appeal of Belize were indeed the law, it would offend so many things that we are accustomed to as company lawyers and commercial persons. So what are the practical takeaways from Beth Clifford for business leaders? I would suggest that they should maintain your personal affairs separate and apart from the company's affairs. You ensure that intercompany transactions are properly documented. You should remember that courts are not looking to punish business owners for control or complexity. So there's nothing wrong with setting up a complex structure. And the final takeaway, I think, is that the corporate veil is strong, but you should not think that it is indestructible. The corporate veil cannot be used, as I intimated, for unlawful purposes or purposes which are not within the contemplation of the incorporation within the Companies Act. I would close by observing that closing that the Clifford case is a reminder of something fundamental. It is a reminder that the corporate veil is one of the most important legal protections available to business people. It allows commerce to flourish. It allows risk-taking. It allows innovation. But it must be respected. And when it is respected, courts, especially the Caribbean Court of Justice, will protect it. I thank you.
Justice Burgess, brilliant as always.
Thank you.
Very clear, very simple. I think we would all agree that we understand what you just said. Justice Jamadar, do add to our learning.
Yeah, thank you very much. Let me just see if I can get my screen shared, and then we can proceed, I think. Okay, there we go. So just to confirm that you're seeing the screen, are you? Okay, great. Excellent.
We are indeed.
All right, great, excellent. I mean, it's a hard act to follow Andrew because he's, as always, clear, organized, structured, and so I'm not even going to try to
no, we want you to try
anything. No, but I'm not going to try to supplement anything that he did. I think he has done what he has done so excellently. But what I am going to try and do is to introduce participants who are here with us to maybe thinking about this from a slightly different perspective, which is explored in the Beth Clifford decision, albeit mainly in the opinion that I wrote. But it is a thread that I think is important as we move forward, both in terms of corporate governance, company law, if you wish, but also in other areas of the law. And so I want to start with an idea. The idea is this idea around new wine and old wine skins, and the just practical experiential insights that if you put new wine in old wine skins, the old wine skins can't contain them, they break, they burst, and the wine is lost. And so if you're going to put new wine, you need to put it in new wine skins. And so I want you to hold that metaphor in your mind as we move along. I'm going to come at this from a constitutional perspective. I just want to just get my timer up so that I do not exceed my time by too much. I may go over a little bit. And so what I want to talk about is constitutional imperatives and new wine skins. And so that's the idea of what I want to talk about. With independence came disruption of the legal order. And that disruption is a constitutional disruption. It's a disruption because certain fundamental things changed in the legal order that governed us for a long, long time before the 60s, basically. And that was putting the Constitution at the center, declaring that it is supreme, and that any law or governmental action inconsistent with the principles and values of our constitutions, they're void. It also So that's different because the UK, certainly for the Anglo-Caribbean states, they have no written constitution. They have no supremacy clause. For them, Parliament is supreme. And so the courts, for example, cannot strike down per se legislation passed by the UK Parliament. They can read in or read down, but they cannot strike, which under our constitutional system, the courts can. There are also entrenched Bill of Rights in our constitutional documents. Again, not present in the UK. And some of you may not be aware, but in fact, our Bill of Rights are modeled not after British common law principles, but largely after the European Convention on Human Rights. And if you look at it, you will see a cut and paste in most jurisdictions, generally, the exception being in Trinidad and Tobago, which did not follow the UK model, but actually did the cut and paste from the Canadian Charter of Rights. And so, in addition to that, is this idea of the separation of powers, yes, present in the UK constitutional setup, but in which courts were given special power for both constitutional and judicial review, and therefore to strike legislation down, as well as executive action. So that is the context in which we have to, I'm going to suggest, look at our legal order. And so in a way, there is this disruption from the colonial approach to the legal order that we have ushered in our region. What does that mean? It means that if you look at the top diagram, you see, for some of us in the region who may be not that young, a little older, you may remember carts pulled by, it could be mules or donkeys or horses or cattle, bullocks, whatever it is. And that would be kind of familiar. And in a sense, if you think about that, and you think about the outer circumference, that's sort of our legal order. And you have these spokes that are radiating out, and each one was a kind of a discrete area of law, including corporate law. And they are around the center. Constitutional law per se was not part of this model. It was a model in which you have silos of contract and tort and so on, but all radiating out to consist or compose what we call our legal order. What I want to suggest and invite you to reflect is what happens when we put the Constitution as supreme and we say that all laws must align with it, and if not, are void. What happens, and I invite you therefore to look at the diagram, the little image below. When you place the Constitution and constitutional values and principles at the center of the wheel, and you say, this is what must govern the entire legal order that we are seeking to reconstruct, then you have what in a case called Marion we describe in the CCGI unanimously as a chiastic impact. That is to say, an impact that radiates throughout the entire legal order, radiating outward from this resonant center of constitutional values and principles, reforming the entire legal order and informing every branch of law. So, if you go along with that, then one would think quite clearly this should have some implications for company law and corporate law. Because, of course, the historical approach has been that's in a silo, that's to be dealt with on its own, and don't infect it with all these constitutional ideas. That's for other things, you know. I'm suggesting we need to rethink that. And in Beth Clifford, that rethinking is undertaken. New wine, new wineskins. So that's the metaphor. Because if we have a new constitutional order, then we have to have new wineskins. And those new wineskins, therefore, become all of the different areas of law. They have to somehow be able to accommodate this new wine. Otherwise, they're not going to be able to hold the gift of the wine, the fruit of the wine. They're going to break and we're going to lose the wine. What is the wine? The wine are the constitutive constitutional values that we as people in the region have said, these are the values and principles that must govern the way we choose. It's a social contract to govern ourselves in constitutional democracies. And so, for example, our learning has said, private law is not exempt. The common law is subject to constitutional principles. Statutes are. State contracts are. But what are companies? Because this is a discussion for company lawyers and the corporate sector. Companies have no existence outside of statutory permissiveness. They are creatures of statute. And statutes are laws, are for sure, right? Statutes must be interpreted consistent with constitutional values. So that's a simple logic. Companies are statutory creations. Statutes are laws, self-evident. But laws must be interpreted consistent with constitutional values, and that is your supremacy and consistency clause in your constitution. So the logic, I suggest, is irrefutable. And what it does, therefore, is it puts constitutional values at the center of the interpretive, the hermeneutic exercise when we come to interpreting our company laws and applying them. Well, what Andrew did wonderfully well was to take us through the sort of statutory interpretation, what I would suggest maybe more orthodox, more familiar approach to what do we do about disregarding the corporate veil or lifting it or piercing it. And what I am offering is that, yes, we follow that, but that must also align and be filtered through the constitutional values and principles that are relevant. But these are not two paths. They are, in fact, a single path that intersect post-independence and post-independence constitutions. What does that mean? It means that when we read our statutes, in this case, the company law, the Company Act in Beth Clifford and Belize, we must filter its sections through Belizean Constitution, in this case also St. Lucia, because one of the companies was in fact incorporated in St. Lucia, and make sure that our interpretation of the Act aligns with the constitutional values and principles. And that therefore, it's not a case of two separate paths, but the alignment of the approaches. What does that yield? In short, it yields the principle of legality. The principle of legality at a constitutional level is inherent in the rule of law. At a constitutional level, it's inherent in the basic structure of our constitutions, meaning it's constitutive. And so that is the constitutional grounding for the principle of legality. The principle of legality informs the entire legal order, and therefore it shapes meaning, interpretation, and application. As a common law rule of statutory interpretation, it mandates that Parliament may only legislate to override constitutional norms using clear language. What does that mean? It means that if the language does not say so, then one has to interpret as an exercise of statutory interpretation, legislative language consistent with constitutional norms. There's a case from 1559 that is sort of the ground, maybe the cornerstone, which says, courts will often imply qualifications into the literal meaning of wide and general words in order to prevent them having some unreasonable consequence which Parliament could not have intended. So what does that all mean? It all means this, it all sort of coalesces into this very simple principle of legality, which says that when we read and interpret a statute, then we must ensure that that reading is consistent with the intention of Parliament, which aligns with the relevant constitutional values. Going to Beth Clifford then, what do we find? What we find is that a company is a creation of statute. We find clearly in the statute the language that says a company can only be created for a lawful purpose. So all of these other words about fraud and this and that evolved over time were disconnected actually from the statute. And so if we have to be faithful to the language of the statute, a company can only be created for a lawful purpose. And that's generally in the language of all our statutes. Therefore, a fortiori, if it is used unlawfully, the logic I suggest is irresistible. The veil that is the benefit of lawful incorporation and use falls away. And so there's nothing too mysterious about it in our analysis in Beth Clifford, because the veil is a protection given for the lawful use of a company. Why? Because the statute only allows the creation of a company for a lawful purpose. Hence, as I've said again, just to repeat, if it is used unlawfully, then that becomes the entry point to inquire, can the veil be lifted? Companies incorporated in Caribbean states are statutory creations. They are therefore subject to the rule of law and to the principle of legality to be broadly interpreted and applied. Correspondingly, the use of a company for an unlawful purpose or for a purpose contrary to law can, and I underline can because I'll come back to what Andrew said in a moment, can lead to the removal of the protections afforded by the corporate veil. I don't want to do more because I have very limited time. I have 12 minutes and I'm on 13. So the can means that it's not, it is to be filtered, because you remember I spoke about the alignment between the statutory interpretation and the constitutional principle. So everything that Andrew said in his key takeaways, that tutelar slide about the constraints and the, all of that applies. All that I wanted to bring across to add to what Andrew shared with you and to the conversation and to your thinking about this is to sort of zoom out a little bit for you and to look at this question, not just sort of, the woods from the trees, not just from amongst the trees, but to zoom out a little bit, look at what happens post-independence, look at the constitutional impact on our legal structure and how that should implicate our reading, interpretation, and application of, in this case, legislation, the Companies Act, and to demonstrate how that can work to come up with a test, which is called the lawful principle test, for disregarding corporate veil, and the suggestion that it can be described and disregarded, can be disregarded if it is used for an unlawful purpose or a purpose contrary to law as an underlying principle. Thank you very much.
Thank you, Justice Jamadar. And what you've spoken about is so relevant to us in Jamaica, because we are having so many instances where statutes are being challenged on the basis that they are breaching the Constitution. So that is actually very live in Jamaica. But of course, as we have this discussion, I can't help but think about companies like Enron, where companies were established, subsidiaries were established to do what would have been lawful things, climate derivatives, the innovative things that we're referring to. And at the end of the day, those companies were used to shelter bad businesses. And when the story came to bump, we had the largest corporate bankruptcy to have ever hit the world up till that time. Shareholders lost billions, as did employees, pension funds. So the whole use of companies and what they can be used to do is something that has real and meaningful impact in the business world. So I'm just throwing that into the mix because that is where corporate governance comes in. Because as we know, and as was said, a company is an inanimate creature, it's a legal creation. And it is the board that gives it the values, the people that we put there now to say, yes, the law says for a lawful purpose. And we, as the custodian of the values, we have to ensure that that is complied with. And at this point, I would ask Ramona Vansluytman, who comes at this from a very much a business perspective, to weigh in. Ramona, tell us what your thoughts are.
Okay, thank you. Thank you, Camille. I am going to add a third perspective, following the two gentlemen, the comments of the two gentlemen preceding me. From an operational perspective, I'd like to put in my 2 cents in terms of the value of this particular judgment with regard to doing business in the Caribbean, especially from the perspective of Guyana. We are emerging now with oil and gas and the multitude of or the diversity of the various operations and companies coming to operate in Guyana, trying to maneuver usually between 2 to 3 continents. Caribbean countries now, we have to participate in financial transactions as well as operational transactions with multiple banking institutions as well as other compliance agencies. And as those companies come from varying continents and countries, they have a diverse set of rules sometimes that do not necessarily mesh. When I look at this structure that was created by Miss Beth Clifford, I really don't see here any kind of deliberate act in trying to be complex. What I am seeing is that this woman was attempting to create a machinery within which to operate, given the fact that there's some financial considerations of the transfer of large sums of US dollars, which consequently results in exchange losses with the US dollars as against whatever currency that they were dealing with. Maybe there were 3 different sets of currencies. I'm not sure what they were doing. But when I look at the exchange losses, I look at the US company having to make a wire transfer to a particular company within the Caribbean, which I am seeing would have had limited structure, limited resources, but was created for a specific purpose of it being a vehicle by which she would have been conducting business. And from what I can see, it actually was an effective vehicle. And I see here that the LCW investments, the opinion I have coming out of this is that LCW investments, in fact, failed in their own due diligence in terms and their legal drafting. If LCW had a responsibility to do their due diligence with respect to the various companies that comprise this business deal that they were pursuing. They were complaining about things like the lack of bank account and the lack of a physical address. An address is not necessary for you to conduct business, especially if you're a multinational. For you to be able to maneuver this situation here, I can see clearly this Miss Beth Clifford would have had a business idea in terms of how to harness whatever skill set she had and sell it outwards. Being she would have structured herself as, I'm not a landowner, but I will align myself to landowners who will allow me the agency to be able to sell these interests. But what vehicle do I utilize? I can't do it personally. So I will incorporate all these little bits and pieces and then hand over the shares, which of course minimize your tax burdens, all these transfer fees. Within Guyana, a conveyancing fee right now is astronomical. For us to transfer properties from one agency to the next, it's costly. Usually a transfer of shares is the most effective way of doing that. So from what I can see here, if you do your basic due diligence in the company's registry from the perspective of beneficial ownership disclosure and all of those things, you can see clearly which companies are owned by who and what assets they have and so on and so forth. And a simple solution for LCW and all of these matriculations would have been personal guarantees. If they felt that they were vulnerable because some of these companies were not necessarily capital heavy, they could have asked for some kind of personal guarantee on behalf of Miss Beth Clifford if it was that she had assets. If they were going to say, listen, you are a single shareholder company and as a single director, you are in fact utilizing the corporate machinery within which to put all of these puzzles in place for us to be able to do business with you. But in addition to that, we are concerned that if you take our money as a shareholder or as a director, you may be able to utilize your powers and authority within that company to move the money elsewhere. But when I look at the judgment, I would have seen that it was clear that she used the monies as intended. This very infantile approach to get Beltway to become somehow liable is surprising to me. Really, this is surprising to me. This, from the perspective of a company being utilized as a payee, literally these are financial transactions that are done for bill settlements, and every single day transactions are conducted whereby companies undertake the responsibility for a fee to have monies routed through them for disbursement purposes. And these things are usually a drafting responsibility. In terms of a contract and legal drafting, you make provisions with regard to A, B, C, D, E, F, G. And if A happens, B follows. If B doesn't happen, C follows. So in this regard, this was a storm in the teacup. And I do believe that LCW lacked proper legal advice and legal drafting skills on behalf of their own attorneys. Their due diligence was poor, I would imagine, because if they had done a proper due diligence, they would have been able to put some stopgaps in. There are a multitude of regulation and compliances between the various jurisdictions with respect to doing business, whether in the real estate context, whether in the building context. A lot of the delays that occur within these sectors are not necessarily deliberate. From even throwing in the political issues that each economy faces, each jurisdiction faces. In some countries, it's easy to get building permits, while in others, it's a nightmare, and it's a lot of lobbying and all of that. I suspect that LCW were sore losers in that they may have been suffering some financial losses due to delays. I saw here that Miss Beth Clifford would have attempted to fix and correct some of what was happening contractually, but it was rejected by LCW because they wanted an outright win, so to speak. But in this regard, I'm very happy to see the Caribbean Court of Justice be very clear with regard to the contractual breach, the breach of contract and the contractual obligations of these companies versus piercing of the corporate veil. In my humble opinion, the corporate veil should never even have been in consideration in this case. It's just strictly contracts. And in terms of the interpretation of those contracts and the breaches for which were admitted by Beth Clifford in the original company, she would have accepted responsibility through GDP. I suspect that she may have also been attempting to correct some of what went wrong. And I do believe she bit off more than she can chew. I think that instead of being a one-man operation, she may have needed to have retained some professionals to assist in managing these multiple balls she was juggling. But I see nothing wrong with what she was doing. It is all, for me, it's all a vehicle and a machinery. But we do have to make sure that in the juggling, we don't juggle more than we can juggle, for want of better terminology. So I'm happy about this kind of decision coming out of the CCJ, which shows us clearly that in doing business in this global economy, we need to be able to see things all around, whether constitutionally, whether from the jurisdictional perspective in terms of the various compliances, and from the Guyanese perspective for us. We are living in the Stone Age when it comes to banking laws. There is an urgent need for constitutional reform together with statutory reform with regard to our banking laws and many other laws that govern the business and other corporate sectors in our country. Our laws are woefully inadequate. And in that regard, we are sometimes taken advantage of. And in that regard, the corporate veil has been used successfully in our country for manipulation and other purposes, much to the detriment of Guyanese investors. And I believe sometimes even what was the word I'm looking for? Our government. I do see some very complex corporate structures being utilized to get around a lot of our local content rules, regulations, and so on. And for me, I think that there is some need for urgent reform across the Caribbean in order to allow us to compete in the first world, especially in cases where from the first world perspective, these machinations have been going on for decades, whereby all of these, like Miss Camille would have mentioned with Enron, this is child's play to the first world countries in terms of how to set up for legal purposes these complex company structure that allow people to shelter under them doing legal business, so to speak. But ultimately, ethically, corporate governance comes into play, whereby the ethics have to be explored, because sometimes a legal purpose does not necessarily match an ethical purpose in terms of what
Exactly,
you're doing.
Ramona.
And that's my 2 cents.
That was a whole dollar. Thank you, Ramona. And you have opened up so many other areas that could be explored. Yualande, Wayne for us, please. Yualande Christopher out of Jamaica.
Thank you so much, Camille. That was so good, Ramona. I enjoyed that thoroughly.
Thank you.
It's such an honor to be part of this esteemed panel. Thank you for having me. And when I was preparing for this panel discussion, I read the Beth Clifford case twice. First as a lawyer examining the doctrine, and again as a governance practitioner, scanning for risks. Because I asked myself, what exactly is the law? And secondly, what does it mean for a person who's sitting in a boardroom on a Monday morning? And that question of what does it mean for someone who's sitting in the boardroom on Monday is exactly why I'm here. Because we've just heard from 2 architects of some of the most significant corporate law judgments delivered in the region in this generation. Justice Jamadar and Justice Burgess are excellent, and they spoke within the law, about the law. And I want to speak a little bit about what it is inside the companies, like Ramona, and what it means to be governed by that law. What struck me most about this case when I read through it using my governance lens was that Beth Clifford was doing what Caribbean business people do every day. She kind of created multiple companies. She served as a sole director of each of them. She used the treasury vehicles to route payments. She subcontracted operations, and she ran a mean, lean, virtual kind of a multi-jurisdictional structure. And for years, it worked for her. But what the CCGI has told us unanimously, I might add, through 4 separate and richly reasoned opinions, is not that this kind of structure is unlawful. They've said it is not. They've said that if you are going to have a legitimate structure, it is inseparable from the conduct of the controller and the purpose for which that entity exists. And that for me is a governance message. It's not just legal. And for those of us who advise companies and we sit on boards, the message translates into something very concrete. A company is not protected by its structure alone. It is protected by the quality of its governance. It has to act honestly. It has to put its purpose in writing. It has to reduce its inter-company arrangements in writing. It has to have meat on its bones to the extent that it shows that it is genuine and real. And there's one more small thing that I have to mention, because I want to offer my perspective from that of a Jamaican practitioner, because every other voice here speaks out of a CCG appellate jurisdiction, and I do not. Jamaican courts still look to the Privy Council as our final appellate court. And although pressed is not binding, it is persuasive authority. I've seen it work its way into our local jurisprudence through Millingen against Geddes. That was a 2019 decision out of the commercial courts, made its way up to the Court of Appeal. And so what do we do now as governance practitioners and attorneys when we're advising companies that span the Caribbean? You have a special purpose vehicle, and one foot is in Jamaica and another in a CCJ appellate jurisdiction. How do you advise a company like that? It's a live governance risk, and it's one that any company that has subsidiaries and counterparts in both jurisdictions must pay attention to. And so I'll close by saying that what the CCJ has done is to say that the corporate veil is not some impenetrable, permanent shield. The veil holds when governance is genuine. But if governance is not, if it is a facade, as Justice Burgess says, then it becomes vulnerable. Those are my 2 cents to Camille. Over to you.
Great 2 cents. I was trying to write it down. The veil holds when governance is what?
Genuine.
Is genuine.
Not a facade.
And I think that is so well said, because the reality is that governance transcends, or principles transcend jurisdictions. The values of transparency, integrity, and how we ought to run our organizations, that goes across all our jurisdictions. And that's why CAMLA and the Caribbean Corporate Governance Institute exists, to ensure that our businesses across the Caribbean understand that these are baseline principles, and that the veil will hold when those governance principles that we espouse are genuine and implemented. Colleagues, let's open the floor now at this point in time. Who is going to help? I see. You're going to help you. You're going to do that, Camille?
I can't believe the time has flown. I'm just looking at the time and realizing there isn't that much time for engagement, but we will welcome persons who do want to ask questions or engage with the panel. I thought this was so brilliant, and I want to tell you, I'm going away feeling so happy that there has been this clarity in terms of how the law is supporting our directors. So long as Yualande says, it's genuine. And Ramona, I will be coming back to you because you have raised so many issues that we certainly need to bring on this platform and explore to see how we do that in the region. So I just wanted to say, Camille, I know we just have 10 minutes, but I would like very much if any of our participants wanted to ask a question, make a comment.
Yeah, Mekisha.
Their thoughts.
Mekisha had raised her hand.
Madam Moderator.
Mm-hmm.
Yes, Justice Burgess.
Yes, sorry. I'm sorry to impose myself at this point in time, but I can't help but think and thank Ramona and Yualande. They've both opened some very, very interesting doors, especially the door opened by Yualande, which is what happens when you are operating in a jurisdiction which answers to the Privy Council, and the company is also operating in the jurisdiction which answers to the CCJ. What happens in that kind of situation? And I think that Ramona made an excellent point where she looked at the due diligence of LCW. I think that it's wrong to look at Beth Clifford and companies and not look at what LCW did not do. But I just wanted to share my view that these two ladies have opened my eyes to new horizons, and I want to thank them.
Thank you for that. And yes, I do
Camille,
agree with you.
if you just allow me, all
Yes.
good judges know at least 3 words, or 2. I concur.
Very good, very good.
And I was just adding that I do agree with Ramona as well on the due diligence point. And of course, our bankers are so good at that, not just the due diligence, but the personal guarantees and all the guarantees, which in this case, LCW really ought to have protected itself better. So, Kamala, what were you saying? No questions at all?
As yet, but I want to say well, in fact, let me ask the participants. Would persons want to hear Ramona come back and address directors as to exactly the level of due diligence they should ensure is carried out in their organizations when they enter into these types of relationships? So just let us know that, whether you want to email me privately, or I'm seeing Dowen has already said yes. For anybody else, because to me, I'm thinking this is a crucial point, because there are a lot of persons who probably fall into that trap. So Ramona, you see, it's now already a group decision. We need to bring you back. There's a hand raised, Camille. Let's hear from Johanna.
I'd see okay, sorry, go ahead. Johanna, go ahead, Johanna.
Thank you so much for organizing this very important seminar. Sometimes as a practitioner, you think you know it all, at least you can find the answer, but hearing such esteemed voices lend and explain it so simply really does inform. And one of the questions I have is, in the case where there's an entity, say a financial entity, say a credit union, they have a board governing, and certain decisions are made concerning maybe a contract or so. I would like to hear some of our esteemed voices speak to how or what, if any, remedies, like how the practical going, seeking, sorry, just allow me, the practical measures that someone could take, maybe a service provider or some other entity entering into contract can take to as a form of recourse in cases where, for example, the governance is not up to the bar or up to standard. I would really like to hear some feedback on that. Thank you so much.
Well, if I may get the ball rolling to share with Johan, contractual obligations are under the law. And so remedies come to you under the law. It may be damages, it may be, specific performance, those kinds of things, which are actually legal remedies, and they're tied to the contract that you may have entered into. When you're looking at governance issues and whether or not an organization is being properly governed, that's an altogether different issue. And I'm going to ask Camille her thoughts on if you as a service provider working with an organization and you're questioning the quality of governance of that organization in which you are now entering into contract with, what options do you have if you feel the governance?
And apart from not doing business with them?
Right.
Because
that's your option you have.
Yes.
Yes, in a part, so let me just give a little
who you are doing business with. Your second obligation is to get a good lawyer. But then now, remember, fiduciary responsibilities. Directors have fiduciary responsibilities, but it's owed primarily to the company. Right? So there are all those areas that you can delve into. But I think that primarily you have to, as Ramona was pointing out, protect yourself when you are engaging in business transactions. Of course, if you are as a creditor, no, and because if you're a financial institution, then the whole matter of fraud can arise. And fraudulent transactions and fraudulent preference and all those things, which are under the law. And that perhaps Justice Burgess can weigh in here because...
Thank you very much. Just to say that the Canadians have taken a very interesting approach to lifting the veil. And this is just to bring back the conversation within the purview of lifting the veil. They've said that to the extent that you can rely on oppression remedy, they will not consider lifting the veil. So in the example which Joanna has given, she's given it in respect of a credit union. But in the case of a company, the shareholder or the complainant or whoever may very well have an action under the Companies Act. And remember that the lifting the veil doctrine says if you have another remedy, pursue that remedy before you come to lift the corporate veil. So that's something which we should bear in mind, that the lifting the veil remedy is limited, very limited to those circumstances where there are not other methods of redress. So that's the way I would.
And just to add to that, in the decision, we speak of it as last resort. So it's last resort and subject to the unavailability of what we described as effective remedies. And so within those parameters, you have to explore your recourse within, if you want to put it that way, within the ambit of the legal remedies available under corporate structure, corporate law, etc. But our conversation, and I don't know if Johanna was addressing this, our conversation is around when can you disregard the corporate veil and ascribe liability, for example, to controllers, shareholders, directors, as opposed to recourse against the company per se for some form of wrongdoing or otherwise.
Yes, Judge. And just for example, if you have a situation where there's bias or apparent bias, or the manner in which directors are handling a certain item, that was the vantage point from which I asked the question. To what extent can the veil be lifted to then include perhaps any one of those directors personally, if there was reason to?
I mean, it's all dependent on the factual circumstances, and Andrew will say a little bit more. But of course, one of the classic grounds for disregarding the corporate veil is fraud, because fraud would be a purpose that is contrary to law or unlawful. And so it will fall outside of the legality principle. So if there is, I don't know where bias falls. I would think that you'd have to cross a threshold to amount to something maybe more. But, part of what I think we should also say is this in terms of disregarding the corporate veil. It is the impugned transaction that is examined and the relief in relation to that. The company itself continues to exist, right? Lifting or disregarding the corporate veil is not a dissolution of the company. It is for the purpose of this transaction. The company subsists and continues, but for the purpose of this transaction, can we go disregard the veil with the intention of ascribing liability to shareholders, directors, or controllers. Andrew, you want to?
Well, just very quickly, just wanted to underline a point which Kamala made, which is she was looking for remedies before she reached the lifting of the corporate veil, and I think that has to be the correct approach. That is, are there remedies outside of lifting the corporate veil? And I think that I would agree with you that has to be the approach. Last resort. That's lifting the corporate. Thank you.
And we'll give Ramona the final word on this. Yes, Ramona.
I just wanted to add that in the scenario that she was inquiring about, a lot of times this lifting of corporate veil is easier, like if there's sole directors and so, but when you have like a full complement, a full board, a complement of 6, 8, 10 board members, and there's dissent within that board, there's usually the vehicle within your bylaws within which you can file a complaint among yourselves, even as a board, to say, well, half is biased, half is not biased, and so on. Outside of that board colluding to act fraudulently. Within the contract, there's still some drafting room in terms of performance benchmarks, things like breaches that can happen intermittently as you go along in terms of fulfilling the contractual obligations, that there's stop gaps, that when you've reached this point, you can ease your way out of that contract without going the whole thing, because you have set parameters within your contract for performance, like performance indicators and benchmarks. But outside of that, there's lots of room within the Companies Act for board members to ask for review of board decisions. This is in the case of dissenting board members and so on. So there's a lot of latitude and tools available outside of reaching the extreme for lifting of the corporate veil, within which these matters can be dealt with. In addition to which, financial agencies are usually governed by compliance agencies to whom you can make and lodge complaints that are done either through resolved through arbitration and so on. So even without even going to the courts, usually there's a compliance agency to whom you can make certain complaints to, as a contractor or as a member or participant within that organization. For us, we are governed by the Companies Act, as well as the other agencies, financial agencies like the Bank of Guyana and so on, that regulate that company as a whole, that financial institution as a whole. So
thank you for that, Ramona. And I think that said, Joanna,
thank you
I
so
go
much.
back to where I started. You probably need a good lawyer. And at this point in time, I want to thank each and every panelist for your contributions this afternoon. We are all far more enlightened, and I do hope that you will join us again for future panels. And in fact, I know with our CEO, Camilla, you won't have a choice in the matter. Camilla, thank you for putting this on. Thank you to CCGI as always, and I hand back over to you.